I want you to think about your home for a second. Not the mortgage, not the square footage, not the property taxes or the HOA fees or any of that. I mean the home, the driveway you shoveled 100 winters, the tree in the backyard your kids climbed, the room that still smells like someone you lost. Now imagine that someone with a title, someone on a board you voted for decided that your home needed to disappear, not because you broke any rule, because your land was worth something to them. Hear me going to tell you what they did to me. Hear me going to tell you exactly how I used their own paperwork to take everything back. Don't go anywhere. My grandfather built that house with his own hands. I don't mean that as a figure of speech. I mean he literally mixed the cement, laid the bricks, installed the windows himself. It was 1971, Northwest Denver. Back when that neighborhood was open land, the lots cost what a working family could save in 5 years. His name was Harold Baxter, foundry worker, hands the size of baseball gloves, a man of few words and zero patience for small talk. He bought the lot, found a neighbor who also couldn't afford labor, and spent almost 2 years building those walls brick by brick on weekends. When he died, in 2012, he left me the house and a note on the desk in his bedroom. 3 lines. Ryan, this is yours. Take care of it. Don't sell. 3 lines. There was a lot, for a man like him. I was 28 years old. I had just gotten my real estate broker's license. And for 8 years, that house was the realest thing I had. Didn't matter if a deal had fallen through, if a client had ghosted me, if the market had gone sideways. I went back to that porch and the third step creaked and everything made sense again. Then the letter came. It was a Tuesday in March. I had just gotten home after showing an apartment in Capitol Hill to a couple who clearly wasn't going to buy anything. They asked too many questions about the neighborhood and not enough about the unit they'd give away that they used to just looking. I was tired. I was hungry. I was thinking about hating lasagna I had made on Sunday. The envelope was in the mailbox between a utility bill and a pizza flyer. The header said, PINSCRST Ridge Homeowners Association Notice of Violation Third e Final. Third e Final. I read it standing on the sidewalk. Read it again. Then one more time. Third. As in, there was a first and a second that I had somehow ignored. I had never received any notice. Not one. Not any formal note. Not any mail. Not a word at the monthly meetings I attended when I could make it. The violation listed. My side fence was allegedly 14 inches beyond the property boundary approved by the association, violating Section 74 of the External Structures Code. The notice stated that if the violation wasn't corrected within 30 days, the HOA had the right to initiate mandatory removal proceedings at my expense and that delinquency fees could be applied to the property. I looked at the fence. It was the same fence that had been there when my grandfather died. The same one I had reported to the HOA in 2012 when I registered my ownership. The same one my neighbors on both sides had looked at for decades without a single complaint. I went inside, called the HOA property manager, a woman named Donna Rice. Efficient voice. The kind of person who sounds like she is reading from my script even when she isn't. Mr. Baxter, the association contracted an independent surveying firm to audit properties in the neighborhood. The survey identified your structure as non-compliant. Can you send me the survey report? That is an internal association document. Can you send me the previous notices? The first and the second? They were sent by mail. Non-delivery is the recipient's responsibility. What is the name of the surveying firm? It is not association policy to share vendor information. I hung up, sat down at the kitchen table. I realized my hand was gripping the envelope tight enough to crumple it. It wasn't the anger yet. It was the cold feeling that comes before anger when you realize a situation is too organized to be an accident. 8 years as an independent real estate broker taught me something most people don't know. Public records added the memory of the land. Every real estate transaction leaves a trail. Every building permit, every deed, every boundary survey, all filed, all public, all accessible to anyone with enough patience to look. The big developers know this. Real estate attorneys know this. Most regular homeowners don't. I knew. That night, I opened the Denver County record system. I pulled the complete history of my property, original deed, Harold James Baxter, 1971. Transfer, Ryan Thomas Baxter, 2012. Boundaries, 1969. Survey, confirmed by the city in 1970. When the foundation was approved. No subsequent changes on record. My fence was 11 inches inside my property line. Not 14 beyond it. 11 inside it. Whoever had done that independent survey had produced numbers that simply did not exist in reality. So I went deeper. I pulled the HOA as archived minutes under Colorado law. Associations above a certain size area required to fill minutes with the county. I read every single one from the past 4 years. Each was in the minutes of a closed dormitory from 18 months earlier that I found the first piece of the puzzle. One line, almost incidental, buried between discussions about sidewalk maintenance and landscaping budgets. Update on Pinecrest Commons project presented by external consultant Phase 2 approved 3 votes still 1. Pinecrest Commons. I had never heard that name, but I knew exactly where to look. The city of Denver's zoning system is public record. It is tedious, it is poorly organized, it is completely accessible to anyone with enough patience. I had patience. I had anger. That is an efficient combination. Pinecrest Commons LLC had filed a pre-approval consultation for mixed-use development 18 months earlier. The project, demolition of 7 existing residences across 3 blocks including my street in construction of an 86-unit residential complex with ground floor commercial space. My lot was at the center of the identified area. More specifically, my lot was a corner lot, 6,800 square feet, the largest on the street. The only one that had been renovated or updated in 15 years. Developer language, the anchor lot, the one you need to acquire first for the rest of the project to make financial sense. I looked up the registered partners of Pinecrest Commons LLC. 2 names, Carl Dunning, President of the HOA Board, Greg Samuels, Vice President of the HOA Board. I closed the laptop, went till the porch. The step creaked. The trees in the backyard, the same ones my grandfather had planted, moved the March wind. They wanted my house, not because I had violated any rule, because the land each sat on was worth enough money that they had created a rule for me to violate. Without knowing it, had become the only obstacle between them and the project they planned to build on top of everything my grandfather had raised with his own hands. I went to the kitchen, opened the drawer where I kept office supplies, and took out a new blue notebook. On the first page, I wrote 3 words. What they know. On the second page, 3 more. What me going to find out. The next morning, I did what any good broker does before anything else. I talked to people. I knocked on the door of Mrs. Elena Kowalski, 71 years old, widowed, lived next door for 22 years. She offered me coffee and oatmeal cookies like I was a grandchild visiting. Have you received any notices from the HOA recently? I asked. She frowned. I got a letter last month. They said my garage was out of code. Ryan, the garage has been there for 40 years. Nobody ever said a word. 3 houses down, Dennis Pruitt, 54, retired mechanic, had received a notice about the pitch of his dicky. 2 other neighbors had received similar notifications that same month. All of them in the same 3-block area identified in the Pinecrest Commons project. None of them had received prior notices in the HOA's own history. I checked the records. The notices had been created retroactively. I could see it in the metadata of the digital files archived in the Association's management system files created in the same week, with backdated dates of 3 and 6 months prior. They were falsified documents. Filed via a platform that automatically recorded the date each file was created. They had made a fundamental mistake. They had used technology to create a paper trail of lies. The technology had recorded the lie. I opened the blue notebook and wrote, HOA file metadata proof of retroactive falsification. And then I realized I had something much bigger than a fence dispute. I had proof of organized real estate fraud. It was 7:14 in the morning when my phone rang. Unknown number. I answered, Ryan Baxter. Yes. Carl Dunning. A short pause, the kind people make when they want to sound calm but aren't. I wanted to talk about the situation with your property. Informally. No bureaucracy. I was in the kitchen making coffee. I kept making the coffee. What situation specifically, Carl? The fence issue. I think there may have been a misunderstanding. These processes sometimes get more formal than they need to be. Maybe we can work this out in a simpler way. Me listening. How about we grab coffee this week? Talk like neighbors. Neighbors. He had presided over the creation of falsified documents against my property and he wanted to talk like neighbors. Let me check my schedule, I said. But Carl, just so we are on the same page, any conversation about my property will be recorded. It's my standard policy in any real estate negotiation. Just giving you advance notice. 4 seconds of silence. Call you later teu setime. He never called back. I put the coffee on the table, opened the blue notebook, and wrote, Dunning called. Wants to resolve this informally. Backed off when I mentioned recording. And below that, he scared. Use it. 3 days after the HOA meeting, I got an email from an address I didn't recognize. The subject line said only, you are not the only one. The sender identified himself as Tom Greer, not a neighbor from my area, but a homeowner from another Denver neighborhood about 4 miles away called Ridgeline Commons. He had gone through something similar to years earlier. Retroactive violation notices. HOA pressure. In the end, he had sold his house below market value to his words, a developer that showed up right after the HOA got on my back. He had researched the developer. He had found a connection to Dunning and Samuels. Tom Greer was 61 years old. He had worked 32 years as a licensed electrician. He had lost the house where he had raised his 3 kids for a fraction of what each was worth. He had not told anyone outside his family because, again, his words, who is going to listen to our retired electrician fighting a lawyer? I called him that same night. We talked for 2 hours. When I hung up, I had a list of 8 mod addresses across 3 different Denver neighborhoods where the same pattern had played out over the past 4 years. Retroactive notices. HOA pressure. Rushed sale. Developer buying shortly after. This wasn't a misunderstanding. This wasn't a fence dispute. This was a systematic real estate fraud operation. I had become the first target who had sold. I needed 3 things. First, an attorney. Not the kind you hire when you have money to spare. The kind who works on contingency in real estate fraud cases. Someone who would look at what I had in a case, not a consultation. Second, an expert. Someone who could extract and certify the metadata from the HOA's digital files in a way that could be presented as evidence in court. Third, the other victims. Tom Greer was one. I needed more. People who could document the pattern in a way no judge could dismiss. For the attorney, I called a broker colleague who had referred me to a real estate litigation attorney to use earlier when one of my clients had a problem with a dishonest builder. Her name was Janet Burrows, 48 years old, small office in the Baker neighborhood, specialized in real estate fraud and homeowner rights. She took cases on contingency when she believed they had merit. I sent her an email at 11 at night with a 3-paragraph summary of what I had found in the documents I already had. She responded at 6:42 the next morning. I need to see you today. Her office was exactly what I expected from someone who was needing this work for easy money. Organized stacks of folders. To plants that needed water. A collection of coffee mugs from places that clearly meant something personal. Colorado State. A national park. A small town in New Mexico. She read my documents in silence for 20 minutes, while I drank watery coffee and looked out the window at the Baker neighborhood street below. Then she looked up. The metadata is the key, she said. If you can get someone to certify that those files were created on the dates shown in the metadata and not the backdated dates, they claim you have direct proof of document falsification. Can I get that? Depends on how the documents are stored. If it's on an HOA management platform, most of the music systems like HOA Express or Calibre, those systems have audit logs that live on the server, not in the files you download. On the server itself. How do I access the server? You don't, but an attorney with a subpoena can. She closed the folder. Tell me about the other cases. I spent the next hour walking her through Tom Greer and the addresses he had given me. When I finished, she was quiet for a moment. Ryan, if what you are describing is a consistent pattern across multiple neighborhoods, this isn't just fraud against you. This could be RICO. RICO, Racketeer Influenced in Corrupt Organizations Act. Federal law. Each is used when there is a criminal organization with a systematic pattern of conduct. If Dunning and Samuels used those as instruments of fraud across multiple properties, this isn't just civil litigation. This is federal criminal territory. I sat with it for a second. So what do we do? First, you don't sell. Doesn't matter what they offer. You don't sign anything. If Dunning calls again, you talk to him. Normally don't mention any of this. Second, you let me feed for discovery on the HOA records. Third, you help me locate the other victims. I need at least 4 documented cases before I go to HUD. HUD, Department of Housing and Urban Development. They have a division that investigates real estate fraud. If we walk in there with 4 cases or more, they open a federal investigation. And when HUD opens a federal investigation in Denver, the Denver Post finds out within 48 hours. I left her office in the late afternoon with a folder of documents, a signed representation agreement contingency fee. She wanted nothing up front in something he hadn't felt since that March envelope. A direction. Over the next 2 weeks, I worked days as a broker and nights as an investigator. Tom Greer connected me to 3 Marty homeowners who had sold under a HOA pressure tied to Dunning and Samuels. One of them, Arthur Prine, 58 years old, retired math teacher, had saved every single email he had ever received from the HOA in his former neighborhood. Every one, in a specific Gmail folder, organized by date. Arthur is the kind of person who categorizes receipts in Excel spreadsheets and logs his car mileage at every fill-up. God bless him. The emails showed the same pattern every time. Escalating pressure over 6 months. Invented violations. Purchase offers arriving from Pinecrest Commons LLC 2 weeks after the final notice, always below market value, always with a 72-hour response deadline. 72 hours to sell the house where you spent 20 years of your life. Janet filed the discovery request. The HOA responded with a legal objection expected. She filed a reply. The process was moving. Meanwhile, Dunning had tried to reach me 2 more times through Donna Rice vague proposals to resolve the situation without specifying how. Every time she called, I was cordial, polite, and told her my attorney was reviewing the matter. The silence after that phrase was always instructive. Then on a Thursday night, something arrived that I hadn't expected. An automated email from the HOA's management platform, the system where the documents were stored. The kind that gets sent automatically when someone logs into your account or when a document associated with your property is modified. Someone had accessed my violation fees that night, at 10:47 policial militar, and they had deleted the original metadata, replacing it with an edited version of the fees. I forwarded the email to Janet in 30 seconds. She responded in 4 minutes. Perfect. They just added destruction of evidence to the list. Me going to HUD first thing tomorrow morning. I went to the porch. The step creaked. The backyard trees moved in the night air. They had panicked. In the panic, they had matched the exact mistake I needed them to make. Janet filed the formal complaint with the Department of Housing and Urban Development on a Friday morning. It wasn't dramatic. There were no cameras, no speech, no moment you could put in a movie trailer. She sent me a text at 10:23 a.m. that said, filed. Now we wait. I was showing a property in the Wash Park neighborhood to a young couple when the message came through. I kept going. Talked about the sudden exposure in the bedrooms, the distance to the schools, the backyard size relative to other homes in that price range. I smiled. I answered questions. Inside, I was counting every second. HUD doesn't move fast. I knew that going in. Federal real estate fraud investigations take time, sometimes months, before anything visible happens. But what didn't know was that Janet had included in the complaint the automated notification email proving that the fees had been altered at 10:47 policial militar that Thursday night. Active destruction of evidence. That changes the timeline. The following Monday, Janet called. We have an assigned investigator. They call this type of case an expedited review when there is evidence of active destruction. They want the contact information for the other victims. I sent to Greer, Arthur Prine, and the other 3 names that same afternoon. The 30 final violation notice gave me 30 days to correct the fence. The deadline was 12 days away. If it didn't correct the violation which didn't exist, the HOA had the right under its own bylaws to hire a contractor to remove the fence at my expense. charge the fees to the property, in the event of no payment, file a lien against the home. A lien would make any future sale significantly more complicated. In a prolonged dispute, it could be used as leverage to force an unfavorable settlement. Basic mechanics. I knew them because I had explained this exact process to bio clients dozens of times. The difference was that this time I was on the other side of it. Janet had filed an emergency injunction requesting suspension of the deadline, while the discovery process was in motion. The judge had scheduled the hearing for 8 days out to 2 days before the HOA deadline. 8 days. That night I drove to Tom Greer's place. He was renting an apartment now, had sold his house 2 years back and never managed to buy again in a market that had climbed since then. The apartment was clean and organized, but it had the quality of a temporary place that becomes permanent without the person kitchen noticing. Boxes still stacked in the corner of the guest room. Photos on the walls but no frames, just tapy. We sat at his kitchen table for 3 hours. He showed me everything he had: correspondence, the sales contract he had signed under pressure, photos of the house he had lost. It was the backyard that got me, he said at one point, looking at nothing specific. My youngest learned to hide his beak in that backyard. My wife planted tomatoes every summer. When we sold, she didn't talk about it for 6 months. 6 months. We slept in the same room and she just didn't mention it. I let a moment pass before I responded. Tom, you're going to have to testify. If HUD opens a formal investigation, they'll want your statement on record. Can you do that? He looked at me for a full second. Son, I stayed quiet for 2 years because I figured nobody was going to listen to a retired electrician. If somebody else is going to listen, you let me know anywhere I'll be there. The courtroom of Judge Warren Elias at Denver District Court had the temperature of a walkie refrigerator in the silence of a place where people choose their words carefully because every word gets written though. Janet was to my left with 3 organized folders in front of her. Across the table, the HOA's attorney Craig Lenehan. Expensive suit. The kind of lawyer who charges $300 an hour and makes sure you know it. 1 folder. The expression of someone who expected this to be quick. It was not quick. Janet presented the original file metadata captured before the alteration in the automated notification email showing that someone had accessed and modified the files after she had filed the discovery request. Your Honor, she said, with the calm of someone who had done this many times before. We are looking at deliberate alteration of documents after legal notice of pending proceedings. We are requesting not only suspension of the deadline, but a full freeze of all association digital records until discovery is complete. Lenehan argued that the metadata was technically ambiguous in that the alteration had been routine administrative maintenance. Judge Elias looked at him for a moment. Routine administrative maintenance at 10:47 on a Thursday night, the judge said. It wasn't a question. Lenehan didn't respond. The injunction was granted. Deadline suspended. Records frozen. The judge added an order requiring the HOA to preserve all server backups from the previous 18 weeks. We walked out of the courthouse at 2 in the afternoon. The April sun in Denver hit hard on the Colfax Avenue sidewalk. What now? I asked. Now they know they've lost control of the process, Janet said, opening the car. And when people like this realize they've lost control, they do one of 2 things. They disappear or they attack. Which one do you think Dunning is going to do? She tossed her folder on the back seat and looked at me over the roof of the car. Carl Dunning has been a lawyer for 30 years. He is going to attack. 3 days after the hearing, I received a formal letter from Dunning's personal law firm, not from the HOA, but from his private office, on letterhead with 2 addresses and 4 named partners. The letter stated that I had HOA meetings and communications with other homeowners, made defamatory statements against Carl Dunning and Greg Samuels that had caused damage to their professional and personal reputations. The letter threatened a civil defamation lawsuit with claimed damages of $400,000. $400,000. I sat at the kitchen table with that letter in my hand and did what anyone would do in that moment. I thought about how much money was in my checking account and how fat that number was from $400,000. Then I called Janet. Pepe, she said before I finished reading her the letter. What is that? Strategic lawsuit against public participation. It is when a person or company uses litigation not to win they know they want to win but to cost you enough money that you give up. Colorado has had an anti-SLAPP statute since 2019. If the judge determines it qualifies, not only does the case get thrown out, they pay your attorney's fees. So what do? You do nothing. I handle this. In Ryan, this letter tells me something important. What? He desperate. Experienced attorneys don't file SLAPP suits when he confident. They file them when he scared. They got nothing better. I hung up, looked at the letter one mighty moment, folded it carefully, tucked it between 2 pages in the blue notebook. He wrote underneath it, he scared. Then I went till the porch. The step creaked. The trees moved. My grandfather had built that house. Numa inexpensive suit, a downtown office was going to take it from me. It was 53 days from the complaint till the phone call. 53 days which I kept working, kept showing properties, kept answering emails, kept showing up. Janet had gotten the SLAPP dismissed at a summary hearing. The judge had taken less than 20 minutes to conclude it was exactly what it was. Dunning had been ordered to pay Janet's fees for that specific hearing. Small win, but a win. Then on a Tuesday morning, Janet called with a different voice. Not urgent controlled, but with something underneath it. HUD has assigned a senior investigator till the case. That means they found enough of a pattern to escalate internally. In Ryan, they requested access to the records. Judge Elias froze. What does that mean in practical terms? It means that at some point in the next few weeks, a federal agent is going to walk into the HOA's office with a subpoena. No advance notice. Everything on that server, including the original versions of the metadata they tried to delete, goes into federal custody. Will Dunning know it is coming? Not until it happens. I was quiet for a second. What about the other victims? Tom, Arthur, the others? Had once for my statements from all of them. Me coordinating. Ryan, you build a case, didn't expect to get it this fast. That happened because you documented everything from day one. I thought about the blue notebook. The pages full of dates, names, metadata, addresses, conversations. Loaned it from a broker, I said. Public records added the memory of the land. The night before the HUD operation, which I knew was happening because Janet had been notified 24 hours in advance, so you didn't do anything that could compromise it. I went out to the backyard. It was around noon at night. Denver has that sky that darkens slowly, blue turning purple turning black. The mountains on the western horizon is still visible as silhouettes long after the sun is gone. I sat down under one of the trees my grandfather had planted. A cottonwood, the kind old Denver residents recognized because they were common before the neighborhoods got newer, muddy uniform. It was about 25 feet tall now. Grandfather had planted it when it was barely a foot high. I sat there for a while without thinking about anything specific, just looking at the yard, the house, the porch with the step that creaked. Don't sell, he had written. He had it sold. Tomorrow, a federal agent was going to walk into an HOA office and start unraveling what the men had built over years at the expense of families who hadn't waited to fight back. Greer was going to get to testify. Arthur Prine was going to get to show the mail folders he had kept with the meticulous organization of a man who knew, deep down, that it was all going to matter someday. I was going to keep sitting in this backyard. I went inside, opened the blue notebook till the last written page, added one line. Tomorrow. I woke up at 5:47 without an alarm. Made coffee, sat on the porch. The step creaked. Denver was quiet the way it only gets before 6 in the morning. That silence that isn't empty. It's just a city breathing before it starts. Janet had told me there was nothing for me till the day. HUD operates independently. Federal agents don't call interested parties before an operation to give her team updates. I would know what happened when she knew. She would know when the assigned investigator contacted her. Work normally, she had told me. Don't stay home waiting. HLL drive you crazy. So at 8:30 I was inside a property in the Sloan S. Lake neighborhood explaining to a young couple why the recently replaced central heating system mattered for energy efficiency through a Denver winter. My phone stayed quiet until 11:19. Janet's message had 3 words. It happened. Call now. I stepped outside till the sidewalk and called. 2 agents went to the property manager's office at noon this morning with a federal subpoena, Janet said. Donna Rice was there. She cooperated, immediately handed over the server access credentials without resistance. Did she know what she was handing over? I think she knew exactly what she was handing over. I think she had already decided that was how it was going to go. Ryan, the agents found 3 layers of feeds on that server. 3 layers. The public layer, what homeowners could see. The edited layer, what they created to replace the originals after your casa started. A third layer they didn't know existed. She paused just long enough for me to lean. The system has automatic backups. They run every 72 hours regardless of any action by the administrator. Those backups had the original feeds with intact metadata, including feeds tied to 8 other homeowners across 3 different neighborhoods. I stood still on the sidewalk. A dog walked by with its owner. A car turned the corner. 8 homeowners, I said. 8 documented cases of falsified violation notices, with dates, names, in the original versions compared side by side with the altered versions. Ryan, they built their own prison inside the HOA server and they didn't know the system was making a backup copy every 3 days. I closed my eyes for just a second. Dois Dunning, no. Agents went to his office at 10 this morning, with a second subpoena. Janet called again at 3 in the afternoon with something you hadn't expected. The HOA has called an emergency meeting for tonight, 7 o'clock at the community school gymnasium. Why? Because Donna Rice resigned as property manager at this afternoon. E-writing, with copies sent to every board member into the county records office. A pause. Because Alain Breck, one of the board members, called 3 neighbors. He asked them to show up. He wants to speak publicly. Alain Breck, the board member with the vague expression I had watched sign things without questioning them. Apparently he had decided to stop signing. Should I be there? You can be there. But Ryan, don't say anything. You haven't cleared with me first that Michi's is still legally their territory. Stay in the audience. Watch. The gymnasium looked different from that first Michi. The first chimney, 20 people spread out, half of them on their phones. This chimney, there were at least 70. Neighbors I recognized, the others I had never seen. Some from adjacent streets. Some didn't place at all. Togreal was a chair toward the middle, arms crossed. Arthur Prine was 3 rows back with a folder on his lap. Carl Dunning was not there. Greg Samuels was not there. Patricia Fosse sat at the front table with the expression of someone who hadn't slept well in several days. Alain Breck sat beside her with a single sheet of paper in his hand. When the meeting was called to order, Alain Breck asked for the floor immediately. He was 62 years old. Teacher S voice, the kind that carries without forcing. He stood up with the sheet of paper, read without looking at the audience, like he needed his eyes fixed on the page to keep going. I have been a member of this board for 4 years. I signed documents that were presented to me as routine administration without questioning them adequately. I understand now that some of those documents were part of a scheme that harmed homeowners in this community and neighboring communities. I did not know the full extent of what was happening, but I signed, and it is my responsibility. He folded the paper. I am resigning from the board effective immediately. I am making myself available to cooperate fully with any ongoing federal investigation. The gymnasium was silent for 2 full seconds. Then the questions started, one after another. Neighbors who had received notices. Neighbors who knew others who had sold. Neighbors who simply wanted to understand what had happened in the neighborhood where they lived. I stayed in the back, watched. Togreal raised his hand at one point, and when Patricia Fosse recognized him, he stood up and said simply, "My name is Togreal. I lived in Ridgeline Commons. I sold my house 2 years ago because I received notices just like the ones you got. You didn't have money for an attorney. I just want you to know it wasn't a coincidence." He sat though. The woman next to him, someone he hadn't seen before, put her hand on his arm. The room stayed quiet for a moment after that. The kind of quiet that means something landed. The federal investigation took 36 days to result in indictment. Carl Dunning and Greg Samuels were indicted on charges of wire fraud, conspiracy to commit real estate fraud, and destruction of federal evidence. 2 other individuals connected to Pinecrest Commons LLC whose names had appeared in the server documents were indicted alongside them. The Denver Post ran the story on a Thursday morning. Front of the business section, then shared to the main page early. The headline was direct. HOA presidents indicted in coordinated real estate fraud scheme spanning 3 Denver neighborhoods. Janet sent me the link at 6:12 in the morning with one line. You hear the third sentence of the second paragraph. I opened the article. There it is. The investigation was triggered after a homeowner, identified as a licensed real estate broker, documented inconsistencies in HOA violation notices and filed a complaint with the HUD, a real estate broker, a blue notebook. 53 days of patience. Call Dunning lost his Colorado bar license 90 days after the indictment suspended preventively, while the criminal case was pending. The law firm lost 4 of its 5 partners in the weeks that followed. Greg Samuels shuttered the joint practice. Pinecrest Commons LLC was dissolved by court order. Assets frozen. Donna Rice, the property manager who had cooperated immediately with the federal agents, was not indicted. Her testimony was central till the government case. Patricia Fosse and Alain Breck were not indicted. Alain Breck became interim board president and led a full review of every violation notice issued over the past 4 years. 23 were voided. Of the 8 families identified in the server records who had sold under pressure, 5 filed civil suits against Pinecrest Commons LLC, its partners personally. Janet represented 3 of them. I can't tell you what each of them received. The settlements were confidential, but I can tell you that Tom Greer called me on an afternoon in August, with the direct voice of a man who does not waste words, and said, I was able to buy back, not the same house that one is already gone, but a lot in the same neighborhood. I am going to build. I didn't say much, because there wasn't much that needed to be said. On a Friday evening in September, I closed my laptop after the last contract of the week. I went to the porch. The step creaked. The backyard trees, the same ones my grandfather had planted in 1970, moved a light wind. The cottonwood at the back of the yard had started releasing its seeds the way it does every September. Little white pieces of cotton floating across the yard like summer snow. My grandfather had sat on that porch for 41 years. I had sat there with violation letters, with blue notebooks, with the fear of losing the only place that mattered. I had sat there after hearings in before federal operations and on nights when I didn't know if any of it was going to work. I was sitting there now, with the house still standing, with the step still creaking, with the trees still there. He had written 3 lines. Ryan, this is yours. Take care of it. Don't sell. I hadn't sold. I looked at the yard for a while. No rush. Just looking. Then I opened the blue notebook till the last blank page. There were plenty left. I had only used the front section. I wrote 1 line. I took care of it, Grandpa. I closed the notebook. Let the step creak one more time as I stood up. I went inside.